Good morning. Welcome and thank you for joining us for the first session of our virtual in-house counsel seminar titled Upside Down, Privacy and Data Security LARP. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your MC for this session. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. If you've attended any of our other in-house counsel seminars in person or virtually, you know that traditionally many of our sessions are very interactive, and we want to take the same approach today. So throughout this session, you'll have the opportunity to answer questions via our polling software. Opting in to participate is easy. Take out your mobile phone and text the message WS Webinar to the phone number 22333. So you'll open a new text message in the phone number area. You'll enter the number 22333. And in the message portion, you'll type in WS Webinar and hit send, and that should log you into our polling software. So let's get started with speaker introductions. Today's speakers are Angela Dowdy, Chris Hope, and Bridget Wellborn. Angela is a North Carolina State Bar Board Specialist in Trademark Law and a Certified Information Privacy Professional, United States, who also serves as Ward & Smith's Director of Legal Innovation. Chris is the Senior Director of IT and Security at OneSource. Chris has a 17-year history of working in information technology and cybersecurity. In the last 2 years with OneSource Communications, Chris has focused on managing the IT services and security services portions of the business, supporting over 1,100 companies through multiple IT and security service lines. Bridget is the Senior Vice President, Privacy and Records Management at First Citizens Bank. Bridget is an experienced attorney with a focus on privacy, data protection, and technology matters. Prior to her current role, Bridget served as the Corporate Secretary and Senior Counsel of the bank and its publicly traded financial holding company. Angela, I'll turn the mic over to you and we can begin.
Welcome everyone. Just to kind of set the stage, I wanted to reiterate what Jen just said about this being a LARP, which is a live action role play. We typically are together and we were hoping to be together this year, but that's unfortunately, not the environment we're in. And so usually through our LARPs, we walk through realistic fact patterns and discuss best practices and tips. We're not really usually focusing on legal requirements or regulations. And so we are going to have to pivot a bit since we're not all sitting at the same table. We are going to, like Jen said, rely on our polling questions. So it's always the polling questions that make this the most fun when we're not in person. So please, everybody participate. And we will start with our first poll to kick it off. And our first poll question is, what is the privacy B word? And this is a free form response, like anybody can put in anything that they think of that starts with a B surrounding privacy. Breach. Somebody clearly is in privacy. Nothing else? Breach, yeah. Now y'all are just copying each other. Somebody's got to have something else. Bridget had a really good one. Bankruptcy. All right, well, it's clear everybody knows what the privacy B word is. It is the dirtiest, naughtiest word in the privacy landscape. It is because it has so much legal significance, and it is always the first question that when something happens, people want to know. But there's so much that, which is a really good one. I'm sure that as soon as Bridget gets the call, that's the first word that comes out of her mouth. But there's so many things that lead up to getting to the B word. So despite everybody's always focusing on, is it the B word versus what, I'm sure Bridget and I are constantly like, incident, we got an incident. let's talk about really what we do as professionals, whether you're in-house, whether you're the forensic team, whether you're external counsel, when you get that call. So we'll talk about a fact scenario. Let's imagine that you are one of two in-house attorneys for a closely held logistics company. You operate nationally, you've got 200 people, and you have about annual revenue of 20 million. Then imagine, or pretend, because we all know this would never happen, that you get a panic call one late Friday afternoon from your human resource director telling you that an unknown party has hacked the company's official Facebook page and posted the names, addresses, and truncated social security numbers of every employee at the company. Your HR director also tells you that the same unknown third party accessed the CEO's email account and sent official-looking spoof emails to all the employees about the information posted to Facebook. Of course, immediately the HR director is probably either saying or asking, has there been a breach? Everybody's demanding an answer. So what do you guys think? Do you think there's been a breach? We know this is Facebook's problem, which we know is not true because nothing is Facebook's problem. This is Outlook's problem, right? They control the emails. Too soon to tell, or definitely a breach. Okay, well, so it's close. Maybe too soon to tell, definitely a breach. Well, let's look at what Bridget would say in this situation. So we already know what everybody's asking, but what first actions do you take? When you get this call, what do you do?
So the first step that I would recommend starts before any potential incident ever occurs, and that is planning. So how do you plan for this type of event? You can't. But what you can do is have an incident response team. Now, if we have global companies on the call or regulated institutions such as banks or healthcare entities, this is something you're familiar with. But what do I mean by an incident response team for the company in the hypo, where I'm one of two in-house counsels? We have about 200 employees. And the answer is, an incident response team is, who do you call? Who do you call when this type of situation occurs? So you're not wasting valuable time scrambling to find out, who do we call? Who needs to be involved? So if you do a little pre-planning in advance to identify internal stakeholders in your company that would need to be involved to make decisions for the company if this type of event occurs. So some great examples would be, you've already called your in-house counsel. That's a great first start. You know, do you have an information security or a chief technology officer? You're going to want to involve them or someone high up on their team. HR, this is another great person to have. And maybe people from leadership that know about your potential cyber coverage or can get involved on the operation side if you don't necessarily have those positions in-house. And the next thing is, you know, your internal stakeholders, who you're going to call external, outside counsel. Do you have a forensic firm that you want to call? Do you know the parties to contact for your insurance policy? So a little bit of pre-planning is going to go a long way when this type of situation occurs.
I have to ask, what's the worst thing that somebody can do when they get this call?
Panic, right? like we all hear it, right? Equifax, Target, Kroger, everyone has had a significant incident that is in the news, and everybody panics about how bad it looks and how much it's going to cost. And just so eager to get to the answer Do we have a problem that's going to require us to notify customers or employees or offer credit monitoring, that people panic and don't step through the process of, all right, well, what happened? And then from what happened, what can we do about it to make it right?
So in the world of nobody likes to make telephone calls and they prefer email and text, we're going to say don't. Because you're right, everybody makes that assumption it's a breach, and then you've got all of these texts and emails and false information going around. What about you, Chris? Like, from a forensic perspective and an IT, what guidance are you giving? What is the best practice for, preserving and investigating into what happened and making sure that, you're balancing yes, investigation, and yes to getting back to business?
Yeah, so the number one when it comes to the IT side of things is to make sure that it can't get worse, right? We need to make sure that the attacker, the threat actor, does not still have any access to the environment. So that's going to be things like changing credentials for compromised accounts, potentially shutting down systems if there are servers or workstations that are compromised, engaging with your incident response team on the IT side, who's going to be doing the triage of what happened and where has access been gained, so that we can isolate and contain and make sure that it doesn't continue to get worse. So that's going to be the number one thing from the IT side. But a really important aspect of doing that is to make sure that we're not doing anything destructive, right? Changing credentials and shutting down systems doesn't damage the evidence of what was done on those systems, but it contains them so they're safe. What we don't want to do is delete anything or remove anything from systems, because what we can end up doing is compromising the evidence that's available for the investigative team to be able to analyze and understand exactly what happened. And if we've lost that evidence, it really can never be gotten back. So you have one opportunity to preserve that. And so, getting the threat actor out of the environment is priority one. Doing it in a way that protects the evidence for further investigation is really key. And as Bridget said, know who your partners are, know who you're planning to work with, who is going to be your call for cybersecurity insurance. Do they have preferred partners or vendors? Do you have preferred partners or vendors for investigation and remediation? If you haven't determined that before a cybersecurity incident, it's really painful to figure that out on the fly. So a little bit of legwork on the front end now before any incident, it goes a long way towards making these incidents manageable.
So to that point, Bridget, what are the typical roles and responsibilities that you assign the different team members, and what expectations do you have during this investigation for all of, external counsel, your forensics team, your internal response team? Kind of how do you handle that?
So I kind of mentioned it a little bit before, but when you're assembling your team, the number one thing that I need to have is decision makers at the table. Because what we don't want to go through is everyone to get together, talk about steps and decisions that have to be made, and then someone has to call a timeout so that they can find the appropriate party to ask for permission. Because time is really important once you discover that something has occurred. So what are people's responsibilities? So when you are working with outside counsel, so in this type of situation, that would be my first call. And I'm really looking for outside counsel to set the tone in terms of, here's what we need to do, step one. Here's our scope. And by scope, I mean jurisdiction. We have employees in the United States, in these states. We have employees in Canada, maybe the EU. What are those implications? Then we are working with the forensic firm on hold until we find out more information from the forensic firm, but they're going to help us fill in the blanks from outside counsel's roadmap. Internal stakeholders, those are going to be the decision makers. So it's also good to have some idea about worst case scenarios. Okay, if we have an incident that's going to require a notification, What type of notification are we going to send? How are we going to do this? If it's our employees, how are we going to reach out to our employees? Should we have a town hall? Should we send a company-wide email? Maybe not in this situation, since we know that there may have been a compromise of internal email accounts. So there's just a lot of planning at this stage and talking through different scenarios to understand that we will be able to move forward once we have additional information.
Well, let's turn to that additional information. So the incident response team has been formed, the team roles have been assigned, and as part of his role, the IT director has engaged a forensic company to ascertain as much information as possible about the incident. And the report comes back and it confirms that the email did in fact originate from the CEO's email account, and that the Facebook posting was made 30 minutes before the email was sent, and both actions were taken from the same IP address. Most concerning, the forensic report reveals that the bad actor accessed the CEO's login credentials, which then gave him unrestricted access to all company systems, viewed and forwarded a specific email between the CEO and the HR director containing sensitive employee information, including full social security numbers, and removed that email and the CEO's login credentials from the system completely. So now that we have the very vital incident response, and your organization did a very good job of not trampling the murder scene, so the forensic folks got in there and they were able to get all the evidence that they needed. What does everybody think now at this point, now that the forensic report is in hand, and everybody is then calling Bridget again to say, is there a breach? Because we all know they want to jump to the conclusion. So do we think we have a determination of a breach at this point? Say yes, most likely, the attorney's favorite answer because they're not going to commit, or no. So a lot of people are very strongly in the yes category. And I would say most likely, but it's still a little bit too soon to tell. While this type of information did show in the forensic reports, we haven't talked about things like encryption or redaction or where that scope and that jurisdiction is, because when you're assessing these things, it can be hair pulling to say you have a breach in this state, but only an incident in this state or this country. So still a little too soon to tell. But forensic reports like this are key during these types of investigations. And so we talked a little bit, Chris, about what organizations, should do in terms of preserving and not trampling. But what is the typical timeline for these reports? What can you expect to be in these reports that are valuable? And how can organizations communicate with their forensics team to make sure that all of the needed information is in there?
I think one of the biggest myths of security forensics investigation is that it happens in minutes or hours, when in reality, we're measuring it typically in days or weeks. Even for smaller incidents or fairly tight scope, there's a lot of detail, there's a lot of logs and information to go through to have a clear understanding of what happened. That said, forensics teams are structured so that they provide you the information as quickly as possible to give you actionable information to move forward on. So in general, you're not going to be waiting for a finalized report, because that may be 2 or 3 weeks out from an incident. You're going to be getting real time or near real time, daily or sometimes multiple times per day in the early stages of an incident, updates from the forensics team with current status and information. It's not going to be a complete picture. It's not going to be everything that will be in the final report, but it'll be enough information to start the decision-making process and to start knowing what the scope and impact is for your organization. So having that incident response team available, plugged in with the updates from the forensics team is really important, so that they have the information they need to be able to consume. what you're really looking for in a forensics report, and what the quality ones will all contain, is all the W's, right? So that's the who, what, where, when, why, and how of an incident. What they're not going to tell you is, what should I do about this, or how do I respond to this, right? They're not in the business of determining your business risk or your path to remediation. They're going to give you the information on, how did you get into this state, not how do you recover from this state. And that's really where a separate task comes to the incident response team, of determining, now that we know the W's, the W words, who, what, when, where, how do we move forward? What is our path forward as a business? Do we have the ability to recover? Are there reporting, right? And so that's the place where your IRT really steps in to take the information off of the forensics report and determine your path forward for the business.
What are
Chris,
you doing?
what I
Oh,
don't
sorry.
hear you saying, and I think it's really important to point out, is that your forensic report will not say you have had a breach.
Correct.
Because if it does, you want to change that before it's a final report. Or
It should not.
Yes, right. So I want to highlight, you didn't talk about that. I think it's important that that is not what the forensic report is going to do. It's going to tell you what happened, but then a breach is a legal conclusion that should not and will not, if Chris has done it, be a part of the final forensic report.
Right. IT people are not legal experts, and I will not claim to have any expertise in that area. So I can tell you what information left the system. I can tell you what information needs to be considered in breach analysis. But then it's really counsel's determination to say, based on this scope of information, based on the states and countries which we're bound to, let me do the analysis to figure out if there is a breach based on this collection of information. And really, that's your area of expertise, not mine.
But we all appreciate forensic teams that don't put that in the report, so that we don't have to go back and highlight all of those B words and have them removed. Bridget, well, what are you doing while the forensic team is working on this report? Now that you've got this information, what are you doing to prepare? What does this highlight about your organization that you may or may not be concerned about, regulations you may be thinking about, compliance? Like, what is running through your mind as Chris is digging through your systems?
So for me, this hypo is your employees. You have had a potential incident involving sensitive information of all of your employees. So this is maybe an opportunity for legal to counsel other stakeholders. But while we're waiting for the forensic report, we need to start having discussions about, what are we going to tell our employees? Because even though it's strongly looking towards the fact that we have had an incident or the B word, we owe our employees something here. Something has happened. Employees are going to be talking. If I'm an employee of this company in the hypothetical, I'm going to be upset. Why was my information posted on Facebook? Why was an email with my social security number sent and then potentially compromised between the CEO and the HR director? So if the incident response team can start there in the valuable time about how we're going to communicate this, what are we going to tell our employees? Because also this was a very public incident that happened. It may need to go a step further. Not only what are you going to tell your employees, but then what are you going to tell your customers if you can't keep your employees' information confidential? Have you damaged your reputation to your potential customers? So working with internal stakeholders to get some communications drafted. Think about what we're going to say to our staff. That's maybe at this point what I'm going to be doing while I'm waiting for the forensic report. Now, what do I think these additional facts have told us about our company's privacy practices. It highlights two big concerns about the way that we do business. And the first way is going to be access controls. The hypothetical talks about how the CEO had unrestricted access to all systems. Now, in the hypothetical, this is a company with 200 employees. Is the CEO a working CEO in the day-to-day matters so that that individual would need access, unrestricted access to every system? I would challenge that. This would be an opportunity after you have made it through the investigation and any potential responses that are required to take a look at your practices. Do employees need unrestricted access to all data within the company to do their job? And if the answer is no, then there are solutions available that can help you set access controls to limit this type of event from happening in the future. If we lock down information and data to only what employees need to do their job, it's just taking an additional precaution. So access controls is one. Then the second thing is the email. Why did the CEO email the HR director and include all of this information about employees? Is there a better way to communicate that message than email? There's always going to be mistakes in email. Is there a share drive? Is there a, dear Mr. HR director, please go to this database, click these buttons, and you'll get the report that you need. So take a look at your email practices and how you're sharing information internally between your employees.
Chris, as Bridget alluded to, there's technology and that kind of stuff in place to help with this, right? The email that directs you to a secured space, the locking down of information. And I'll say the first thing that I usually hear from clients is, you know, either our customers don't want to deal with, or our employees don't want to have to deal with encrypted emails, or this is going to be expensive and we, you know, can't afford to put in all of these technologies. How hard or expensive are these minimal preventative measures, such as excluding access to certain information or having a platform in which encryption is required for certain information?
So there are certain practices that you can put in place that are 100% free. And least privilege is the one that comes to mind in this scenario that will cost the company nothing but a little bit of time and effort. And that's the idea that each employee, all the way up to the CEO, only has access to what they need to be able to do their job. So the things that the CEO needs to be able to do his job in directing the focus of the business are not the same things that his VPs are going to need, and they're not the same things that their managers are going to need, and so on and so forth. So aligning people's access to their actual job responsibilities and needs is free. There is no technology cost. It is a little bit of time and effort, absolutely, but it is something that every company can implement today. Beyond that, encrypted email is absolutely one of those things that can and should be looked at by most companies dealing in PII, right? There are companies that where it doesn't necessarily make good sense to their business model, but if you have PII in your business, then it's an appropriate measure to think about. And it's not a particularly expensive one, but even better than that to me would be two-factor authentication. Because right now we know that the credentials were compromised, right? The username and password of the CEO was compromised, and the threat actor was able to use said username and password to get access to additional information. Well, what do we do to be able to prevent that behavior? You know, we can't guarantee that no passwords ever get out into the wild. It's impossible. But what we can do is create a system using two-factor authentication where you need a password and an additional factor to be able to access your systems, and especially access the systems that contain PII or protected information or business critical information, right? So that is one of the first things that I would recommend. As far as cost, you're talking about somewhere order of magnitude about $10 to $20 per employee per month. So somewhere in the, for a 200-person company, somewhere in the $20,000 to $40,000 range per year to implement a two-factor authentication system, and to either have it fully managed through a provider or to hire some staff to be able to manage that. But when you compare that to the cost of a cybersecurity incident, which in 2021 was 4.62 million average cost for a single cybersecurity incident, that 20,000 to 40,000 is pretty appealing at that point. It's a multiple order of magnitude difference in investing in some technology choices up front compared to having to deal with the fallout of working your way through one of these incidents.
Especially when I hear from clients all the time, well, we have insurance for that. And there's so many caveats to insurance, and you really have to read those policies because some of them require encryption or, you know, other compliance regulations for them to cover you. So even if you think you have insurance to cover, you know, the cost of that breach, you could still be out in the cold when it comes to it because you've not done what's been required to qualify.
And even if your current policy is mute on that effect, we have seen a trend in the industry where if a company goes through an incident, there are mandatory changes that their insurance provider will put on them to be able to continue coverage. They will say, if you want to continue coverage after this incident, then we are requiring you to put certain practices in place, or we will not insure you.
Well, let's talk about one of the things that I'm sure all of the attorneys on the webinar are thinking. Okay, so we've got this very expansive forensic report. Are these findings discoverable in litigation? If you got sued by one of your employees, would you have to post this forensic or provide this forensic report? Yes, no, or it depends, which again, because all of you are attorneys, we're going to go with the depends, which is fair and it is accurate. It does depend, and one thing that's can be very frustrating is the depend can be jurisdiction specific. So not only are you thinking about jurisdiction in terms of what privacy regulations apply, now you're into the litigation arena as to where would you be sued, what's required within that jurisdiction to make that forensic report not discoverable. So Bridget, you know, just focusing on North Carolina, as an attorney and the privacy officer leading the response team, what practices are you implementing to protect that forensic report? And just positioning the organization to minimize as much information as possible as being discoverable.
So the first step is to engage outside counsel here. If we know that we're going to need a forensic report, we're going to let outside counsel take the lead on engaging the forensic firm and getting the final report accordingly. But then internally, what are we doing to protect any kind of privilege that we may need in the future? And that is to really educate your incident response team. Do not forward emails. Do not send text messages. Invites for meetings to discuss interim findings from the forensic firm or to discuss next steps. They all have large disclaimers and notices both in the calendar invites, in the body of the email, at the top of the email, talking about attorney-client privilege. Do not forward outside the bank. Do not forward to internal employees. The group has to maintain its small size. And then we really have to be careful about how information is shared outside of that small circle.
Chris, what about you? I mean, what kind of information or details and stuff are you looking for from Bridget to kind of guide how you come up with your final report? Like you said, there's, you know, it's coming out in pieces, but at some point you get to a point where you have a finalized report. How does that communication go?
So when outside counsel is involved, they're really going to direct the format, form, and content of what that final report looks like. We've worked with a lot of different counsel in the past, and sometimes they want the very, very minimal information, right? They just want the facts and nothing but the facts. Thank you, ma'am, right? And sometimes they are okay putting a little bit more conjecture and hypothesis in there. But really, that's outside counsel's determination to decide what the structure of that report looks like. And they'll work with the forensic firm to make sure that that makes sense and that what gets written down and published, quote unquote, as the official copy makes sense from a legal perspective and is doing the best job of protecting the business. So that is something that most businesses don't have to worry about directly, because the legal team is going to be handling that. As far as the update process, and Bridget mentioned this as well, it's really important to keep the group just contained to the IRT. As much as we want to start pulling in additional people and additional resources and help, and like, oh, I think it would be really helpful if our IT admin could sit in on this meeting and learn, it's not a good idea to bring in additional people into the forensics investigation reporting, because what you open yourself up to is the possibility that you haven't kept the privilege, right? By opening the net too wide, you could possibly be creating a situation where you're violating your own privilege by disclosing that information, and now it could be discoverable. So that keeping that group very tight knit, keeping it just to the IRT, to the people who are named as part of your incident response plan, is pretty important.
And I've experienced that where, oh, I want to bring someone in to train them so that they can see what happens. That's what a tabletop exercise is for. That's not for investigating a real incident that has occurred.
Well,
We didn't mention this at the beginning, but honestly, tabletops are a great way to do planning before an incident ever happens. I sat in on one yesterday that we were helping a financial institution through, where we were doing a tabletop exercise for their annual process. And they have an IRT, they have an incident response plan, and our role in it was to create a incident, quote unquote, that they were responding to, and they could actually go through the exercise and train on how they would respond to it in real time. It takes a 4-hour meeting, and doing that once a year is a great way to build the habit, to build the routine, so that when you're in a real cybersecurity incident, it doesn't feel like crisis mode. You have a little bit of muscle memory to go back to. You have some practice to be able to fall back to know how you're going to handle things.
it's also a fun way to do training because there's not the real stress. And so there's some team building, and you do really start to see the capabilities of the different people. So that is a good point. I do like the table topic training for many reasons. Well, we all know that there has to be some benefit for a bad actor to do that. So, I mean, he's gone through all this trouble. And as it turns out, this bad actor isn't done with our company either. Saturday morning, the CEO receives an email threatening to publish all the information they were able to access on the internet, including the employee's sensitive financial information. So remember, this information hasn't been published yet. It was truncated on Facebook, but now they've got the credentials, they've got full names, full social security numbers. So it felt like the panic had passed, and maybe it has some, and you get this email, and often we see now people are indignant and they're angry and they're staring at this email and thinking, I've been a victim of a crime. Surely my company isn't responsible for bearing the responsibility or for bearing the cost of having to unwind this crime, this criminal activity. But despite being a victim of a cybercrime, do you guys think the company remains responsible under the applicable privacy and data security laws? Very strong in the yes. I like the depends. This is probably one of those times that I would say it doesn't depend. It is absolutely yes, that if there are applicable privacy laws that say that we have had the big breach, regardless of the fact that we've been a victim of a crime, and while we may be working with law enforcement, the company does still have to deal with the aftermath of the breach. But then the question becomes, do you pay the ransom? So you've already got all of these costs with unwinding what happened, but there's now what do I do with the ransom demand? This feels scary. We know that the information left our system. And there's varying thoughts on this. Bridget, would you ever consider paying the ransom in this type of situation?
No. And I knew this question is coming, and I thought about a nice way to deliver that. And there's not, particularly as I sit in my seat for a regulated financial institution, the answer is no, because there are implications. It is potentially impermissible and could result in civil and criminal penalties if you pay a ransom. If you're a financial institution, again, you have to consider OFAC issues, paying a ransom to an individual in a country on the sanctions list. So there's just too many factors. And then this is more Chris's area, but you could pay the ransom and it doesn't mean anything. You are not getting your information back, and it's already out there somewhere. So
they're coming back for more. If you pay them, they're coming back. Chris, how often does this happen? Like with mid-sized companies, is it a regular occurrence that once this has happened, demands come in, or are some people just out there for funsies going in and creating havoc and walking away?
It is pretty common that if you have data loss, that somebody will be coming after you for money. There's no clear statistics about this. Did a little digging before this exercise to try and get some numbers for you guys. The last numbers from North Carolina specifically were published in 2019. And in 2019, there were 1,200 data loss incidents, meaning where data was exposed externally that were reported to the State Bureau of Investigation. So those are going to be fairly significant, large incidents. If you're bringing in the equivalent of the state version of the FBI in North Carolina, right? So that does not include any of the small businesses that did this under the radar and handled it themselves or directly with the team and didn't bring in a investigative counterpart from the government, right? Police investigation. So the numbers are very high, like shockingly high with how often this happens. And what we do have numbers on is that about 50%, just over, it's 52% of companies will end up trying to pay the ransom. Of those, 29% are able to get what they were promised, right? Whether that is privacy, meaning I won't release your data, or whether that's recovery, meaning I'll give you the key to unencrypt your data so that you can get back your ransomware systems. So 29% of those who paid the ransomware got what they were promised. That's a really bad ROI, right? Sub 30% ROI on typically hundreds of thousands of dollars of cash payment is not good enough. It's simply not good enough. And then the other factor that I feel obligated to point out is by paying the ransom, we're effectively supporting the criminal activities. As tempting as it may be to feel like I can just get out of this, it's a little bit of money and I can just get out of this bad situation. The reality is we're encouraging the behavior, we're supporting the criminal activities, and we're making sure that this happens to another company and another company after that, because we're funding the people who are doing this activity and allowing them to continue making money and sustaining this practice over and over and over again. So we never recommend paying the ransom in our investigations. 0% of the time are we going to recommend that. I'll be honest, sometimes companies make the decision to do it anyway against our recommendations, but it never makes practical sense to attempt it. And as Bridget mentioned, what we've seen a lot is that even companies who pay the ransom, if they don't then take the time to go in and remediate problems and fix security holes and change the way their business operates on the IT side, they are incredibly likely to be attacked a second time, and often by the same threat actor who got them the first time. Because now the threat actor knows, oh, I've got somebody willing to give me money. I'm going to go back to that well and I'm going to try again because I worked the first time and they've got the same security holes this year that they had last year. So the incident of repeat attacks against companies that pay ransom is shockingly high.
Yeah, and I have to admit, we don't ever recommend paying ransom for a lot of the reasons you mentioned, but then also the mindset of this is how I get out of it. The problem is you've already had the breach. You already have to follow through and deal with all of the legal obligations and requirements. So, you know, it's scary to think that they're going to publish it, but honestly, even if they don't publish it, bad actors have already got their hands on it. And if they are going to breach your system, you can be sure that they're going to use the information for some nefarious purpose. And so I always recommend that instead use that money to provide remediation to the people that are impacted, right? So credit monitoring, or, you know, with inside, we had one employer that actually had a, you know, here's what a credit freeze is, and here's, you know, how you put fraud alerts. And so using the money you would pay the criminal and instead use it to empower those that are already been impacted anyway, is one of the ways that we approach it. So we have now decided we're not paying the ransomware. We are moving forward, but just as everything seems to be calming down and the response plan is sketched and we're looking at the forensic, the HR director reread that forensic report and realizes that there are COVID vaccination card and the status of each employee that had gotten removed from the system during this entire incident. She immediately calls you and wants to know, or says, there's been a Hipaa violation. What do you tell her? So everybody that's listening, what would you tell her? Yes, definitely a Hipaa violation. There is health information. No, definitely not. We're not a covered entity. You know, it never applies to us. We're a logistics company, or it depends. Which, as we've seen in the news, the understanding of Hipaa is all over the place. So we got some people saying yes, a couple people saying no, a very large percent that probably has already started to understand my thinking. It depends. And it does depend. I can't tell you how many times that we get calls from clients on a regular basis, either, you know, concerns of a breach versus just, what do I need to do with this information now that the government is telling me I've got to collect it? So I'm sure, Bridget, that you have gotten this question a lot, given the size of your organization and what you guys are having to do. So how do you answer this question? What are you asking and trying to figure out when this type of issue pops up?
So in this situation, the answer is the Angela standard of it depends, right? How did we, the employer, get this information? Was it because of our status as an employer, which is a different analysis than if, well, this information was provided under the health plan and the employer is the sponsor of the employee health plan. So there's going to be different analysis depending on how the information was collected. And so just because it's health information or medical information doesn't exactly bring it under HIPAA automatically. So the very real world scenario here is when there was an announcement that large employers with 100 or more employees would either have to comply with a vaccine mandate or subject employees to regular COVID testing. And so questions came to me about, is it a violation of my HIPAA rights to tell my employer what my vaccination status, and or in the earlier days, reporting if I have a positive COVID test. And if you are collecting this information as an employer regarding the health and safety of your workforce, your customers, and your place of business, the answer is no. If you are an employee and you are voluntarily submitting your COVID status, a copy of your vaccine card, no, that in this case is also not subject to HIPAA. So I agree that there's a lot of information out there that collecting COVID related information may or may not be subject to HIPAA, or more importantly, your employees are asking if it is a violation of their HIPAA rights to collect this information. There is some reassurances out there that no, those very particular situations are going to bring the information outside of the HIPAA regulations.
Well, that concludes our data breach concern, all of the facts that come out that typically occur. We did have a question that I wanted to pose to everybody, and that is, John asked, how often do you see the cybersecurity insurance provider saying to pay the ransom?
I'll take the first answer at that, and Bridget, feel free to add on if you'd like to from your perspective. There are certain threat actors who have better kind of known behavior and known playing nice, right, with people who pay for ransom. There are certain organizations that operate more like a business, right? And they give you what you paid for. But there are no guarantees in the world of ransomware and cybersecurity breaches. So the best that you can possibly hope for is a maybe. I don't like the idea of paying ransom. I personally am opposed to it. Our company's stance is that we are opposed to it. We do not recommend it. There are some cases where the insurance company will advocate it based on the specific circumstances of the threat actor involved and what they have been shown to do in the past with other companies. Does that mean that you have to follow their advice? Absolutely not. No way, no how. It is your decision as a business. It is the decision of the stakeholders of that business to decide the right path forward for themselves. And you do not need to follow the recommendations of the cybersecurity insurance provider to be able to do that. Now, if companies do want to go down that path, just to be clear, there is additional cost there. Quite often there's an intermediary negotiator who will actually contact the threat actor and negotiate on your behalf to try and make sure that there are some assurances in place. But you're taking a criminal at their word that they will follow through on their end of the bargain. No matter who's involved in the process, you have no guarantee that they will do what they've said they're going to do. It's a promise and nothing more. So is that worth hundreds of thousands of dollars of the company's money on a promise from a criminal? I believe the answer is no, despite what an insurance provider may say, but ultimately the business has to determine that for itself.
I have to admit, when I first discovered that there was this good list of bad actors, I was blown away. Like, because to me, the whole thing that makes this so variable from day to day, incident to incident, is that most of the time you don't know who it is and what's happening, but that there are some bad actors out there that are repeat offenders and you know who they are. I was kind of surprised when I figured out that that was a thing. But in the banking industry, I have never encountered the insurance coverage recommending paying the ransom.
I'm the same. I haven't had a client insurance company say let's just go ahead and pay the ransom. Somebody asked if there was honor among thieves. So clearly of the hackers, there is some type of honor among thieves. I will also say that I think paying ransom has changed over the years, right? When I first started in privacy, I think a lot more people were inclined, like Chris was saying, to pay it, get the information back, and just move forward. I think the demanded amounts were smaller. It was almost like the bad actors were balancing, okay, the smaller companies don't have the technology, so we're going to pick them off for small amounts and we're picking off a larger number. Whereas it seems like there's been a shift to, okay, now everybody's getting this technology, so let's aim for the big fish and the big dollars. But the problem is a lot of those big fish they're not paying up anymore. So the ransom is always an interesting question. I will throw one last question out in terms of ransom, and specifically to Bridget. One of the things that we struggle with sometimes when dealing with this is when to call law enforcement, who to call within law enforcement, the fear that law enforcement will come in and take servers and information that could damage the business and the operations. What are your thoughts on involving law enforcement and when?
Sure. So I'm not opposed to calling law enforcement, and you may find that your local or regional SBI or FBI field office under cyber crimes could be a good ally to help coach you. These are the things we want to know about. These are the things we don't want to know about. In my world, I am bringing my regulators along with me before I even call law enforcement. So by the time we get to that point, we have the FDIC, we have the Federal Reserve, we have the North Carolina Banking Commission. There will be a lot of notifications, not just to law enforcement, but government entities on this incident. When there's a demand for ransom, that's probably a situation that your field agent will tell you that they want to know about. And then that's kind of the reasons that Chris articulated, that is this someone that they've seen before? Are they targeting businesses in North Carolina? Is the MO the same? So there are situations where it is a good idea to connect with law enforcement on cyber incidents.
There's so many factors. We had one incident where we ended up reporting and the FBI got involved, and it turned out they were so familiar with the bad actor that they actually had the codes unencrypt the client system themselves. And so it was a very positive experience. We called them very early on. Of course, there were a lot of reasons that we did so in terms of what the loss was looking at and that kind of stuff. And then we've had other instances where clients called before they called us. And, we are like, well, we need forensic. And they're like, oh, well, they just took all our servers. And so we don't, and I was like, what do you mean they took your servers? And so it's always that balance, and just always considering, like you were saying, how much help do you want? Where are you in the research? We never want, Chris and his team to not be able to have access to what we need to make a legal determination. Well, we are at time, and so I just wanted to thank everybody for attending, and I will turn it back over to Jen.
Thank you so much. So thank you, Angela and Chris and Bridget. For those of you in attendance following today's webinar, we will send you an email with a copy of the slide deck as well as a recording of today's session. We did apply for a technology credit through the North Carolina State Bar for CLE for this session. It has not been confirmed yet. It's still pending, but as soon as we do get confirmation approval, we will submit the accreditation materials for attendees seeking North Carolina CLE credit only. If you need out-of-state CLE, please email us at rsvp@wardensmith.com. and we'll send you a certificate of attendance as well as the webinar materials for submission. We so appreciate you taking your time to join us today and hope you were able to take some of the information you learned and apply it to your own organizations. Thank you again. And that concludes the first session of today's virtual in-house counsel seminar.